Have you ever thought about your estate plan? The estate planning process is when a person determines how their estate will be managed and distributed after they die, or if they ever become too incapacitated to manage their affairs. Depending on the size of the estate, some estate planning documents can be prepared without the assistance of attorneys and other professionals. For large or more complex estates, it's advisable to seek the counsel of varying professionals, including but not limited to accountants, attorneys, bankers, financial advisors, insurance advisors, and investment brokers. In this video, we'll discuss common estate planning documents, assets in an estate, beneficiaries, family needs to address, signing requirements, and storing an estate plan. Before we start, make sure to grab your estate-specific template for an estate planning checklist at the link below. And don't forget to hit that subscribe button for more videos by eForms, the world's largest database of official legal documents. First, let's review common estate planning documents. There are many documents that a person can use to build their estate plan. Let's go over what some of those are. A last will and testament is the most common document associated with estate planning. It designates how to distribute the principal's assets after their death. It can be very general or specific based on the principal's wishes. Wills must go through the probate process, which, depending on the state and the size of the estate, can last anywhere from 6 to 12 months. A living trust designates a trustee to manage the principal's assets on behalf of the named beneficiaries. This person is also known as a grantor. It is called a living trust because it can be executed and amended while the grantor is still alive. Living trusts are beneficial because they don't have to go through probate when it is time to distribute the grantor's assets. An advance directive broadly addresses a patient's wishes about receiving future medical care. Patients can also alert their medical team of philosophical, religious, or cultural beliefs regarding medical treatment. Doctors refer to these when a patient has become too incapacitated to make decisions for themselves. A living will is a type of advance directive. It provides specific instructions for end-of-life treatment options for the principal. For example, it can address the principal's desire to receive food or fluids should they become incapacitated. They can also outline their funeral arrangements and specify if they have been paid for. A power of attorney is often included in an advance directive. It appoints a specific person to act as an agent for the principal when making particular decisions while that person is still living but too incapacitated to manage their arrangements on their own. The most common types are financial or durable medical powers of attorney. The designee in a medical power of attorney will make decisions with the principal's medical team based on their advance directive or living will. The designee of a durable power of attorney manages any of the following that belonged to the principal: commodities, gifts, insurance, operating business entities, personal property, real estate, retirement accounts, stocks and bonds, and taxes. Next, let's cover what is an asset in an estate. A person's estate comprises everything that they own, such as bank accounts, business entities, financial investments, life insurance policies, real estate, vehicles, and any other personal belongings. And who are beneficiaries? For any personal accounts that don't require specific beneficiary designations, principals must list beneficiaries in their last will and testament. Detail and specifics are crucial to avoid confusion or ill will when it comes time to distribute the principal's assets and property. Beneficiaries can be individuals, companies, or organizations. Now, there are plenty of family needs to be addressed in an estate plan. A caregiver agreement makes arrangements for the everyday care of an elderly person or a person with special needs. A minor child power of attorney allows a parent or guardian to give responsibility of their child to another adult, usually for a time period of 6 to 12 months. A declaration of guardianship states a person's preference for who they want to have legal guardianship over their minor children or adult dependents. This type of declaration can also be made directly in will. It overrides any existing minor child power of attorney documents. A life insurance policy is an agreement between a client and a life insurance provider that pays out a specified amount of money, also known as a death benefit, to the named beneficiaries if the insured individual ever passes away. Like medical and vehicle insurance policies, clients pay a regular premium for the life of the policy in return for eventual beneficiary payout. Do estate planning documents have any signing requirements? Many states require signatures in the presence of 2 witnesses and a notary public. The witness can't be anyone listed in any estate document as an agent or beneficiary. Signing requirements vary by state, so it is important to verify individual state laws. Notaries are available online at financial institutions, at every UPS store, and through the National Association of Notaries. And what's the best advice for storing an estate plan? After all estate planning documents are complete and executed, it's necessary to have a safe and secure place to hold them. It's also a good idea to provide copies to all agents and beneficiaries listed in any document, and alert the agents or someone else that is trustworthy where the originals are being held. So where can you find legal documents online? If you need an estate planning checklist, advance directive, current assets list, last will and testament, power of attorney, or any other form, we have thousands of state-specific ready-to-go templates available for you to download with no membership or credit card required.